Well, welcome everybody to the first Lunch and Learn here from the CUE network of our 2026, kicking off with a strong one with our wonderful presenters today. So for those of you who may not be familiar with us, we are the Centers of Excellence, and we're a network of five centers across the state in Knoxville, Chattanooga, Johnson City, Nashville, and Memphis. And we are a group of multidisciplinary clinicians at these centers that provide consultation and support for youth involved and connected with the child welfare system, both in state custody as well as at risk of entering state custody, with an array of different services across our centers, but primarily case consultation and evaluation and support for providers more directly. So, very excited to have our presenters today from the Nashville Education Rights Project, from the Nashville Defender's Office, seeking us about education rights for children in foster care. Our two speakers are Lydia Burris, the social worker on the team and team leader. She came to the project in 2014 as a social worker, and then 2023 became the team leader, primarily providing educational advocacy for parents and guardians of children with disabilities in school meetings and connection to other community resources, as well as supporting social work perspectives into multidisciplinary legal representation in guardian ad litem cases, with education from University of Tennessee and Lipscomb University. And then we have Jordyn Conley, one of the education attorneys on the team, who joined in 2021 with degrees from Fisk University and a Juris Doctor from Vanderbilt University Law School. She is, as I mentioned, an education attorney who provides legal representation to families in school meetings, discipline appeals, and due process complaints. Also serves as guardian ad litem practice for youth that she represents, and can serve as an educational surrogate for children when those are needed. So with that, I will hand it off to our fantastic presenters. Just a quick shout out. We have at the Vanderbilt Center of Excellence have had wonderful experiences with this team and are so grateful that they're willing to speak statewide. So with that, I will hand it off to you, Lydia and Jordyn. And thank you, everybody.
Thank you so much. We are so glad to be here. I love working with the Center of Excellence. I am Lydia Burris, like Kevin said, I'm a social worker, and Jordyn is one of our amazing education attorneys, guardian ad litem, and educational surrogate. So this means the work, or like this means the world to us to get to talk about just the intersection of education, the child welfare system, and the juvenile court system, and what we can do to ensure that federal laws are being utilized to ensure that our kids in foster care are having access to all the supports that they are entitled to in school. We want to make sure that they have what they need to be successful so that we can get them graduated and hopefully never in contact with the delinquency system. And so we're going to talk about some supports and access to services that you guys can help advocate for the youth that you work with. And I love the Center of Excellence for so many reasons, for the work that they do with the clients that we serve, for the work that they do across the state, and honestly, just for me as well, because I was able to do my graduate internship with them. And so it has been very formative to me. So thank you all for coming today and for wanting to learn more about the educational rights of youth in foster care. So today we'll be talking about how to foster success in addressing the educational needs of youth in foster care. So we are the Education Rights Project, and we are a part of the Public Defender's Office in Nashville. We advocate to ensure that Nashville's children with disabilities get a quality education, graduate from high school, and avoid contact with the juvenile court system. And so we do that through a variety of ways. We have a couple different programs that we provide. We provide educational advocacy and legal representation to students who have IEPs or 504 plans here in Davidson County. We only work in Davidson County, but we work with kids K through 12 across Nashville, advocating on behalf of parents or guardians and students to ensure that students have those services that they are entitled to, that they graduate from high school, and hopefully either prevent or reduce their contact with the court system if they are already involved. We also, Jordyn can be appointed as guardian ad litem by the court for specific youth who are already in foster care or at risk of going into foster care. And so she advocates for their best interest. And so we try to provide kind of multidisciplinary advocacy for those youth. So I will support her as the social worker. And then in some cases, when students who are in foster care don't have educational decision makers for special education meetings, she can be appointed as educational surrogate. We'll talk a little bit more about that in the second part of our presentation. And then we try to do some policy work when we're able to. And then we also love to provide trainings. And so today we'll be talking about how, federal laws that really, apply to youth in foster care, but we also do trainings about the school to prison pipeline. We do trainings really specifically on special education and discipline law that goes much more in depth on those laws. So if you ever want us to do a presentation on that, we've done them in the past for the Center of Excellence. So you might be able to find them like archived on the website, but we also are happy to do them for your agency or for DCS. So feel free to reach out to us. And this is our lovely team right now. So I'm Lydia. Jordyn will be speaking a little bit later. And we also have Ale, who works with our Spanish-speaking families on the educational advocacy piece. She doesn't work on our GAL team, but she also works on our delinquency office as well. So she wears many, many hats. So here's our contact information. I know the slides will be put in the chat, so you'll have access to it as well. So feel free to reach out with any questions at any time. So today we will be talking a little bit about just the foster care system. School stability will be kind of the bulk of our conversation. Best interest determination meetings, special education, who can be educational decision makers in different parts of the education system, and then particularly for special education, because that can become really confusing. Exclusionary discipline and access to resources and manifestation determination reviews, or sometimes that's called manifestation meetings for kids who have IEPs or 504 plans. And then just briefly, some ways that you can advocate to improve educational outcomes for youth in foster care. And as Kevin said, feel free to put your questions in the chat. So that way you don't have to try to hold on to all of the questions that you might have, and we'll try to take questions at the end. We hope that the presentation will kind of answer some of your questions as we go along, but we're happy to answer questions at the end. Or if we don't get to your question, our information is at the beginning, so feel free to reach out afterward. All right, so we will dive in. So according to the U.S. Department of Health and Human Services, back in 2021, there were over 390,000 children in foster care in the United States. And about 66% of those youth were school age. So about 2/3 of the youth who are in the foster care system were in the K-12 education system. That's a lot of youth. So this really is important to ensure that we are making really important efforts to ensure that students are getting access to the school services and following the laws that children in foster care are entitled to. And so we want to make sure that we are following these laws and advocating on behalf of youth in foster care. And so we can see that you can see this graph about the length of time in foster care. This is based on national data. And so you can see that about 60% of youth are in foster care for over a year. I know the goal is always to get kids back home.
Not at all. I don't know why.
As quickly as we can. Just please make sure that you're on mute. We want to make sure that kids can get home as quickly as we can, or achieving permanency. But unfortunately, kids are oftentimes in foster care for over a year. So it really does matter that we are advocating to ensure that kids are getting what they need to be successful. So you can see just this length of time that kids can be in care. Right. And so we're going to talk about school stability and why it is so important. And I know for many decades we have seen a push towards keeping kids in school, but there's been really a recent shift in ensuring that kids are staying in their school of origin. And why that matters is we know that school attachment, school connectedness, that's a hugely important protective factor for youth. We know for all youth that it can be really important to keep kids attached to their school. But the research has been really predominant to ensure that kids who are in foster care stay in their school of origin. Because by keeping kids in their school of origin, we see that, kids are more likely to be successful academically because they're not having as much disruption in terms of instruction, but they're also having that really important attachment with their peers and adults, and they're more likely to graduate. And so school stability is really paramount. So there was a study, the Casey National Alumni Study found that they found that participants in foster care, that 2/3 of their participants attended more than 3 elementary schools, and 1/3 attended more than 5 elementary schools, which is a lot of schools, right? That's a lot of change. Not only are kids going from home to home as they're changing foster care placements, as they are experiencing trauma, as they are being away from their birth family, but they're also experiencing that school instability. And then when we're also looking at the Midwest study, the 17 and 18-year-olds, some of those kids, 1/3 experienced more than 5 school changes related to being in foster care. So it's really important to recognize how that is impacting our youth, right? And so this study was done in Colorado, and it looked at the amount of school changes that occurred for youth in foster care after starting high school. And of that study in Colorado, only 10% didn't change schools when they were in high school. Almost 50% of students moved 1 to 3 times, and almost 1 in 5 children moved 6 or more times during their high school career. And when we think about high school, I mean, that is such a significant time of adolescent development. For those of us who have worked with high schoolers, that is a very hard time to be getting high school credits. It is always so hard when our high schoolers transition from school to school, because that is such a pivotal time to get those credits. It is so hard to move schools, then to be having to make new friends. When you think of, I just always think of, the proverbial, like, okay, we're moving kids from home to home, and they're picking up their black trash bag full of stuff, but they're also having to do that with their backpack from school to school. And so it is really destabilizing to start over consistently. Like, that is so challenging. And we also know that the research is very consistent, is that when kids are in care and they are moving from school to school, that their academics are most likely to decrease. So math and reading achievement goes down, your graduation rate decreases, and your likelihood to drop out increases. And so you can see here on this graph that the national rate for youth in foster care already, to graduate on time without any change in school, so with 0 school changes, to graduate on time with no school changes, is already in the 50% to graduate on time. So as you see, the line that goes down, the more school changes, the less likely you are to graduate on time. So it's really imperative that we keep our kids at the same school as much as we can. And like I said, we know that the effects of school instability are really significant. And I know for those of you out there who have been teachers, who are teachers, who work with youth in schools, you have seen this in your work. We see that kids who have high mobility from school to school, they have gaps in learning. They've had disrupted instruction. It is really challenging to go even within the same district to start from school to school. because the curriculum, what one teacher teaches at one school is going to be different than another. That from state to state, from district to district, it can be very hard to start over in a new classroom. We see that kids who are in foster care are more likely to miss school. So there's going to be that chronic absenteeism, which really can be challenging for learning. And then, of course, the more we miss school, the lower scores we're going to have on standardized testing. And then we might add in if we have an educational disability. And so we always see that the youth that we work with, it's a really interesting kind of a challenge that we see is because youth who are in foster care are more likely to have an individualized education program and have, receive special education services. So they're disproportionately represented as having an educational disability. But at the same time, there's a real challenge and difficulty identifying students with disabilities when they are in foster care because they are, highly mobile. They're going from school to school. And so that can be really challenging if they're not in a school long enough for a school to really get to know that child and have the time to really see how they're performing academically, behaviorally, complete an evaluation for special education, for the adults in their lives to do really strong rating scales. And so we see oftentimes that some of our youth in foster care, the evaluations may not have ever occurred and they needed to have occurred. It's not Jordyn can, talk about how as educational surrogate, she's had kids who are in high school who have needed an IEP for many, many years, but a parent hasn't been able to sign off for an evaluation for an IEP. We see that oftentimes that the youth we work with have really, unfortunately, and I don't mean to blame some of their previous teachers, but poorly written IEPs, but just because they haven't had the time to really get to know the students on their caseload, because they haven't had time to really adequately get strong present levels, time to get strong goals or to provide really good service for them to make progress. We've seen kids whose IEPs are implemented really differently from school to school, whether that's based on, the IEP not being written well, or they didn't understand exactly what the previous school was providing. One school was providing way more service than was actually in the IEP. So it's when we see that instability from school to school, and the IEP is just going to be implemented differently. We know that kids are going to have to constantly adjust to new schools. That means educational records may not show up for a while at the new school, which doesn't allow the new school to get to know them and read their cumulative file and see what's in there, see previous records, evaluations, behaviors that they would like to understand, discipline. They may not have access to a safety plan or behavior intervention plan. There's just things that don't always make it into the cumulative file that you wish had been in there. I talked about missing high school credits and how that can be really challenging if this school doesn't have the same course that a previous high school had. And so now a kid is missing that elective. And so now they're having to make it up. And so they're behind in getting their credits towards graduation. And then just the attachment challenges, having to constantly form relationship with new peers and staff. That is exhausting. We have a child who's already having to start over in a new home with people they may not know. They miss their birth family. They're probably going through some sort of required therapy through their permanency plan. And you're saying, okay, now you're in a new school. Now start over with new friends, people who may not look like you, who you may not know anything about. You're in a new part of the city, new part of the state. Start over. Staff may not understand you. They don't understand your behaviors, and all of a sudden you have to, do everything that they say, and you have no rapport built with them. That's incredibly challenging. And we'll respond better when we have rapport built with staff or adults or people that we know and like. That can be very, very hard. And then in terms of behavioral health, mental health, social and emotional, we see that youth in foster care, and especially related to that instability of school, the data shows that kids in care related to school instability are going to have increased externalizing and internalizing behaviors. They are more likely to have fewer adaptive behaviors and are likely to have higher rates of school problems. And so when all of this comes together, we're asking a lot of our youth to start over and over in schools. Because we also know that the research is incredibly clear for all youth that school attachment can be a really strong buffer and mitigating factor between adverse childhood experiences and high-risk behaviors. That the research is incredibly clear that having that connection to teachers improves not only your relationships, but it also, like I just previously said, it decreases discipline incidents. You're much more likely, I think of it as an adult, you're much more likely to do something if you like the person. I think about at work. I'm much more likely to do something that my boss asked me to do if I like her. If she asks me to do something I really don't want to do, I'm much more likely to put it off. I'm much more likely to do it to the very end of the deadline. I might forget about it because that's just who I am. I might be frustrated by it. Like we all know this as human beings. If you don't have that rapport built, you may react a little bit different. So when you have that connection built, the data is very clear. When you have that connection and relationship and rapport, the data is so clear that you're much more likely to have better behavior. And there's a really strong research study that shows that having that school connectedness, feeling connected to your school and that attachment, it's a critical protective factor against emotional distress. And this actual study showed that school connectedness it's as strong as it's second behind family connectedness as a protective factor. And so we can't control, unfortunately, for what's going on in our kids' families, but we can really work hard to build strong school connection. And actually, federal law gives us tools to advocate for that. And so we may not be able to say, wave a magic wand for the challenges happening in the lives of our kids' families, but we can advocate for school connectedness. And so we try whenever we can to really build rapport with at least one adult for our kids at school, because the research shows it's really helpful. And luckily, federal law also recognizes that. And so the Every Student Succeeds Act, which hopefully you guys are familiar with, is from 2015. And it follows the lead of the Fostering Connections Act of 2008, by requiring state educational agencies, so like the Tennessee Department of Education and local educational agencies, so your local school district, to work with your child welfare agencies. So ours is, the Department of Children's Services here in Tennessee, to ensure the educational stability of children in foster care. So we're recognizing educational stability is so important. It's critical. And ESSA requires that students in foster care must be enrolled in their school of origin unless it's not in the child's best interest. And so you're probably like, what does that even mean? But we'll talk about that in just a little bit. What is school of origin? So basically what that means is a best interest determination meeting must occur if a child enters foster care or changes foster care placements. So if those two things, one of those things happens, a kid comes into DCS custody or is already in DCS custody and changes foster care placements, they moved into a new foster care placement, DCS must identify, has this child moved into a new school of zone? By either coming into custody or moving homes, are they now zoned for a new school? And if they have, DCS must contact that former school of zone immediately and a best interest determination meeting must occur. And by doing so, the federal guidance, which is really gratefully, federal guidance came out. There's some new guidance that came out in November 2024 that replaced previous guidance, and it is so clear. It's much more extensive. It's very, very helpful. And it's been I encourage everyone to read it if you're working with youth in foster care. And so all of the research that is in here, I tried to put footnotes in it. So like you'll see that this federal guidance, there's like a number 8, the very end of our slides that are in the chat will link to exactly what the federal guidance is. So if you see the number 8 throughout the slides, you'll know that all of that came from this federal guidance. But so the guidance says that agencies should complete this process as quickly as possible. So they want kids to, these meetings to occur quickly to make sure we're keeping kids in school. So they say such as within 3 business days of the student's placement in foster care, or even prior to a planned placement change. So they're wanting us to meet within 3 business days or as quickly as possible of a kid's change in foster care placement. Our state recognizes that's really quick. So our state says please do it within 5 days. And I will just say this isn't necessarily happening within our state. So if you can encourage the DCS FSWs you're working with to really be letting those schools know that your kids are moving placements, that would be great. These best interest determination meetings to discuss should this kid go to their previous school or their new school of zone, they should be student-centered and context-specific. We should be talking about this specific child and the context surrounding that individualized child. We should not be talking about just, processes in general. We should be talking about this kid. And really, the guidance says that the presumption is that staying in their school of origin, the school that they were in before they changed placements, is in their best interest. That's the presumption. And I'm going to say that again, because I don't think often we're starting there. The presumption is that remaining in the school of origin is in the student's best interest, unless the whole team, the best interest determination meeting, suggests that attending another school is in the student's best interest. And when we're having this discussion, we should not be considering how much it costs to transport them and how difficult it is, the burden that it puts on the school and the child welfare agency. And I know, because we've been a part of these meetings on behalf of the youth we work with, that's a large part of the discussion. And now that we've got to consider planning that piece, but we shouldn't be, that's not why we're deciding this kid needs to go to their new school of zone because it's going to cost too much money. That's not what we're basing the decision on. What we're basing the decision on are these factors. And these are just some of the pieces that you can consider. But when you are having these best interest determination meetings, I want you to really have really honest and fruitful and collaborative discussions. So when you're thinking, should this child stay in their school of origin where they were placed before at school or their new school of zone, think about these things. What's their permanency goal? Is the goal to return to parent? Is this an adoption goal and they're in a pre-adoptive home already? How long are they actually going to stay in this placement? Are we here on respite and we don't know how long this respite placement is going to last? We're here for a while? We have literally no idea what we're doing with this kid because we can't find any other placement for them. Let's genuinely be honest. What does the student want? Let's give our students, our youth, a voice. Do they want to stay in their school of origin, or do they feel like it would be in their best interest to start over somewhere fresh? Who is the educational decision maker? What do they prefer? Does the child have siblings? Did they go to one of these schools? How many previous schools have they been to? Is adding another school change going to be disruptive to their school trajectory? How old are they? What grade are they in? Have they been retained? Is this going to be hard to start over? What are their academic and social emotional needs? Are they safe in their previous school? Do they have an educational disability and have an IEP or a 504 plan? Do they receive services at their school? Are they an English language learner? Are they in pre-K? Do they participate in sports or extracurriculars? Do they have an extensive discipline history where perhaps this school knows how to work with them and it would be in their best interest to stay there, or it would be in their best interest to start over somewhere else where they have a fresh start? What about graduation? Are we on track to graduate? Would it be really hard to start over in a new school? Are they connected to their school staff, to their school, to their peers? Do they have friends that it would be really detrimental for them to be away from? If they're being transported from one district to another, how long is the commute? Is that going to be hard on them to be on the bus for that long of a time? What does that look like? Have a very honest conversation, not just a quick, okay, they need to go to their new school. And this federal guidance is very clear. The law is clear about what school of origin means. So the school of origin is the public school that a student was enrolled in when they enter foster care or when they change foster care placements. They must remain in their school of origin for the duration of their time in foster care. So the duration of their time in foster care, unless there's a determination that it's not in their best interest to stay there. And it also discusses like that, like if they're going to the next school. So when we're looking at the feeder pattern, so we have a kid who's in 5th grade, they should go to the next school in that feeder pattern of the district. So that would be their next school of origin. So wherever that school regularly feeds into would be their next school of origin. We wouldn't just then revert to whatever is closest to the school of zone now.
It's annoying.
And then also, I know someone put in who registered early, asked a question about exiting foster care. It's not a state law, but the guidance really encourages districts. If a student is exiting foster care during the school year, the school, states, Department of Eds, and school districts are really encouraged strongly to allow that student, if they're exiting foster care during the school year, to remain in their school of origin through at least the end of the school year, so that student can have some continuity for that school year. So that is something that you can also advocate for. And then in terms of, okay, we've decided that we've looked at all of these factors. We decided they should stay in their school of origin. That's what we're considering. But perhaps we've looked at all of these factors and we've decided it's in that child's best interest to go to the new school of zone. So if it's not in the best interest to stay in the school of origin, that student must be immediately enrolled in the new school. And so the new school of zone or that new district, wherever it may be, they must eliminate the barriers to get that child enrolled. So even if that school does not have the records that they need to be enrolled, that district or that school cannot deny enrollment because they don't have the documentation needed. And as soon as that kid is enrolled, that new school should immediately contact the new school to get records. And this is where it gets a little more complicated because transportation can be challenging, but it should not be one of the considerations on what is best interest. The law is very clear that the child welfare agency, so again, that's DCS for us, and that school district should have clear written procedures on who's going to provide transportation, who's going to pay for it, how it'll be arranged to get that kid to their school of origin, even if it's across state lines, if it's across county lines, if you've got a special school district inside your school district, even if you've got multiple school districts to deal with, if you've got a kid going we only work in Davidson, but if you've got a kid going from Davidson to Sumner County. If you've got a kid you live on state lines, going from Kentucky to Tennessee, you've got multiple, so you got, whatever Kentucky's DCS is, whatever it may be, you've got to coordinate. And that also means that districts are really encouraged to provide transportation to school activities like extracurriculars and to academic supports, summer learning, summer school, after school tutoring, whatever it may be, because we know those are really important to keep kids attached to. And so the schools have to come up with DCS a system to pay for that. And the policy, there's also a DCS policy about this. And so I really want people to know that there is a policy about it. It's Tennessee DCS Policy 21.14. It's referenced at number 10 in our references. And here it is. And so if you ever get confused about this policy, here's most of it. I've summarized it for you all. But just to consider that the student enters or changes foster care placement. The student must, and we see this happen all of the time. And our district sees it. We are so lucky that we work with MNPS in Davidson County because our foster care point of contacts are incredible. Here in Metro Nashville Public Schools, I hope that yours are incredible in your district. We only work in Davidson, so I don't know what yours are like, but man, our hours are amazing. But your student and the student in foster care must remain in your school of origin until the bid meeting occurs. So you can't just enroll that kid in the new school before that bid meeting happens, because you have to decide as a team, is it in the best interest to move to the new school or not? We have to decide about school stability. That child is entitled to look at, should they stay in their school of zone, so that we can honor the spirit of the law about school stability, because we know it is hard for our kids to move. We know what the data shows. The FSW should provide an updated education passport and school notification letter to the school of origin and request that bid meeting. And please, 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 if you're an FSW or you work with FSWs or you know an FSW, you love an FSW, I know they are overburdened, overworked, underpaid. They do too much I have the utmost empathy, but please remind them to update the education passport, because your school district will likely kick back the enrollment because they need to know what is going on with this kid. Often, as I hear over and over, the most likely chance the bid meeting will go to dispute resolution is because the education passport is not updated. Please update your education passport. I can think of a kid that I have worked with where I had to go to our district and basically provide all of the information, even though I'm not an FSW, but I had to say, please enroll this child and give so much narrative information about our client. And it was all because the FSW just did not provide an updated education passport. And he would have had to start at his old school. That would have been completely inappropriate for him. So please update your education passport. And if you're curious, here's a copy of it. And it says every time up in the corner, present this form to each new school or current school for each placement. Every time your kid changes a placement, it has to go. An updated copy has to go. So please do it. The forms provided have current placement changes, contact information for invitations to the bid meeting, along with the school notification letter. Your school of origin will set up the bid meeting. The bid meeting will occur, and that's when that collaborative discussion should happen, where we talk about all of those, factors. And then based on the discussion, the bid team will either decide the student should stay at their school of origin and a transportation plan is developed, or the student should start at the new school and that student will be enrolled and records should be transferred. And this is just some helpful thoughts for you all if you're participating in best interest determination meetings. And these are maybe just to consider them some red flags. If you're in this meeting and you're feeling like we're not really talking about best interest, these are just some of them that we have noticed. and hear about regularly, but your team may not understand the purpose and requirements of the bid meeting, right? The purpose is to really discuss what is the best interest of this child, because the spirit of the law is to keep kids in their school of zone. The school of origin, excuse me, the school of origin, because of the challenges of school instability. Bid meetings being scheduled when there's not been a change in foster care placement, because we have seen schools just quite frankly not want to work with our youth anymore. So they'll schedule a bid meeting because they don't like our students' behavior, and not because our child has changed foster care placements. And so they have decided it's not in the best interest for that student to remain there. And then the decision-making process isn't really meaningful from all relevant stakeholders and isn't really collaborative. The student's already been enrolled in the new school while the bid meeting's still pending, or the bid meeting never occurred. The conversation is really about cost, convenience, resource availability. That educational passport hasn't been submitted. The team's unaware of the student's permanency goal or how long they plan to be in this placement. The presumption that the new school is the best interest prior to having really relevant discussion with the parties. There's really not a lot of adequate discussion about the child's individualized educational factors, or there's been a failure to invite appropriate members, such as the guardian ad litem, the educational surrogate, if there is one, school of origin, CASA. It can be really hard if you don't have those people at the table providing really important context. I know I can think of meetings, especially like for Jordyn, who has known a child for years and can provide genuine context to the team. And, someone maybe perhaps like an FSW who's only been on the case for like 2 weeks is making decisions and doesn't know the history. So those are just some red flags. And if the team disagrees, which it does happen, and that's okay, we all want to advocate for the children we work with. DCS has the authority to make the final decision, but there is kind of a dispute resolution process about transportation, procedures and costs, best interest determination. A meeting can occur. There are forms that you can be filled out. But I always want to tell people that each district has a DCS region education consultant to talk to, an ESSA compliance point of contact if you've got questions about bid meetings. And then also there's 2 incredibly helpful people from the state, Mary Lyle for our DCS, and then one of my personal favorites who I just find incredibly helpful is Jackie Jacobson from the Tennessee Department of Education. She's the foster care point of contact, and she is just amazing. So if you ever have questions, feel free to contact them about dispute resolution. And so when you come back to this presentation, here are just some key terms that could be useful. And I know I can see that we've got some questions, popping up in the chat that we definitely will get to. But I want to hand it to Jordyn to talk about special education.
Yeah, I will be discussing special education and some of those meetings, key tenets of the law, and also go to for kids with IEPs and 504 plans if they are facing exclusionary discipline. So we'll go over that. And yeah, when our kids need or already have an IEP or a 504 plan and they're in foster care, those services just become that much more critical. Getting adequate IEPs, goals, services, behavior plans in place, and having that data so that we can really serve our students well is so important, because not only does it help them succeed academically, it also prevents those instances of exclusionary discipline that then result in change of placements for children or lots of sort of consequences that would negatively affect foster care. really important here. So educational decision makers, so for children in special education, they require educational decision makers to initiate that AP process, to initiate, the evaluation process, to review and sign off on those annual IEPs, and then to request any meetings, that may need to be requested if things aren't going so well at school. So, who is the educational decision maker for our youth in foster care? DCS serves as the decision maker for routine educational decisions, of those maintained by legal parents or services under IDEA, which is our federal education law. When we say routine education issues, that looks like pick up and drop off, enrollment, field trips, who's like logistics sort of conversations. They may be having, maybe going to like parent teacher conferences. However, DCS does not have those special education decision making powers. Um, Typically, birth parents will retain their educational decision making rights under IDEA unless they no longer have the legal authority for that. And typically, that looks like a termination of parental right. And then foster parents collaborate and communicate with the school on a day-to-day basis. So there's, a parent who's been involved with the child. They may be going to those student parent teacher conferences. They'll be talking, through the app or through the portals to the school about homework and things like that. DCS is going to be in charge of enrolling the child and talking about transportation issues. Parents, so IDEA, so the federal special education law requires a parent to sign those IEPs in agreement or in disagreement. And also importantly, IDEA requires a parent to request and give consent for an initial IEP evaluation. So that's where we end up in a lot of sticky situations with our kids in foster care who may or may not have parents with terminated rights, but ultimately need an IEP and can't get those services because there's nobody to request and consent for the evaluation. So if an IEP is already in place, that IEP can roll over year to year when the school meets. And if there is no parent to sign off at that time, then the IEP will go into effect after 15 days. But that initial IEP requires that a parent sign. So I end up as educational surrogate, like Lydia mentioned, with a lot of kids who have needed these services for years, but have never been assigned an educational surrogate, whose parents are sort of like, out in the world somewhere, but not actively involved in educational decision making. And so they're really just sort of like languishing in their education, in the education system. So the law gives us multiple options for what is legally considered a parent. Obviously, we have a biological or adoptive parent whose rights haven't been terminated. A guardian generally authorized to act as the child's parent. So if you've got grandma who has taken guardianship or something like that, person can be authorized to make educational decisions. But if the child is a ward of the state, DCS is not considered, even though DCS is the guardian or the custodian, DCS is not considered sort of eligible to be parent under that category. The law also allows for an individual acting in the place of a biological or adoptive parent. So if they're sort of like de facto parent, the child's been living with them and they've been legally responsible for the child's welfare, this person can often step up as parent for special education decisions. A surrogate parent who has been appointed either by the school system or by the court system, and we'll talk a bit more about that. And then in Tennessee, a foster parent who has an ongoing relationship with the child for more than 1 year can make educational decisions if the biological parent's rights have been terminated. So very sort of specific. We've got a lot of options, but most of them are pretty specific. And the reality is that a lot of kids end up without an educational decision maker. we've had a ton of success with working with COS and DCS. Kids get appointed through the school system with a surrogate, or ourselves appointed as surrogates, if that's the case, that if that needs to happen. So we really appreciate partnering with all of you to help get these kids educational decision makers. Like I mentioned, the school districts can appoint surrogates. They can do it in 3 circumstances. If a birth or adoptive parent is unknown or cannot be located, if a child is a ward of the state, and then if a child is an unaccompanied homeless youth. If a child is in foster care and they do not have an educational decision maker available, oftentimes the school will require that the parental rights of the biological parents have been terminated in order to appoint a. And so, like I mentioned, that's sort of where we get into those scenarios where, as you all probably know through your work, many, termination of parental rights is not a quick or easy process. It shouldn't be. But this results in a ton of kids who have been in the system for a long time, whose parental rights are still intact. They're not involved. So this is where the appointments for surrogate parents through juvenile court can really come in handy. And we have had lots of success with having juvenile court appoint a surrogate where rights haven't been terminated. And so you all find yourselves in those scenarios where the school district is refusing or hesitant to appoint a surrogate, but this child either really needs an IEP, if that's the opinion of the adults involved, or there's suspicion of an educational disability. Juvenile court has the power to appoint a surrogate as well. And I'm happy to answer any questions, or you all can reach out to us about the logistics of getting that done. Perfect. Okay, so the role of a surrogate parent, and I've already mentioned some of this, but providing consent for the initial evaluation of the student and provision of special education services if eligible. So that initial educational eval, that initial IEP development, those are all going to require type of consent on the parent's part. Then the surrogate parent will continue to participate as the role of parent in IEP meetings for the student. Will represent the student's interest in the provision of what we call FAPE, which stands for Free Appropriate Public Education. So basically making sure that that student is receiving an individualized educational plan in accordance to their individualized needs, and that their services, other parts of their plan are getting implemented on a daily basis. And then the parent also, just like biological parents, has the right and the responsibility to pursue dispute resolution if EP team disagreements arise. The surrogate parent retains all those rights, and to file a due process complaint or a state complaint. They feel like the child's rights are being violated, or P is not being implemented, or there's disagreements with the school. Okay, and sort of, though this isn't an in-depth presentation about special education, just sort of to give you all a few key tenets of the law and key terms about special ed that are important to know for our youth in foster care. So one of our favorites, Lydia's favorite tenet of IDEA is child find. And this puts an affirmative obligation on the school to locate or to identify, locate, and evaluate children who are to have a need of special education. So if they have a diagnosis that's been, brought to the school's attention, if they're on medication, if they've, had significant mental health concerns, hospitalizations, if there are significant gaps in reading or math, these are all sort of red flags that would give the school knowledge that this child may have an educational disability that requires an evaluation for an IEP. And Child Find puts that obligation onto the schools. So we can sort of move that process along as advocates for youth in foster care by flagging those concerns to the school and asking for that evaluation. Although the school should be doing that on their own, oftentimes, outside stakeholders are needed to sort of move that process along. And of course, having, advocating for a surrogate parent or an educational decision maker of some sort to be involved so that that process can take place is really important. Under the law, highly mobile children with disabilities must be evaluated in a timely manner without undue delay. We hear this from schools sometimes, like, we don't have their records, we don't have their cumulative file, or we haven't known them long enough to say whether they need, an IEP, or to say whether we should even evaluate them. We've got to have them for a semester. We need to have them for a year. It's not, that's not true. If we have knowledge or suspicion of a disability, those children, even highly mobile, must be evaluated just as, any other child should be. When a student with an IEP transfers schools, the new school must provide comparable services to what is in the current IEP until they can meet and develop an appropriate IEP for that setting. If a kid comes from a different school district or residential facility, the school that they're feeding into should absolutely take that current IEP and implement it as closely as possible until an IEP meeting can be set up and decisions made from there. So there shouldn't be a gap in services. And then even when students experience changes in schools or placement, districts must continue to comply with state and federal special education timeline requirements. We can provide you a list of those timelines, but that looks like, we have to meet annually at least once a year for IEP development to make sure all of the data and the goals are up to date. That obligation is not discharged because the student moves schools a lot. If they're doing an evaluation, that evaluation has to be completed, or that initial evaluation has to be completed within 60 days. So there are timelines for these things. And youth in foster care should not be getting the short end of the stick because of lack of school stability. Schools have those obligations under the law. Now we'll talk a little bit about exclusionary discipline, meaning those out of school suspensions or school. Students in foster care, unfortunately, not surprisingly, students with disabilities are more likely to experience suspensions and expulsions than their peers. We know that youth in foster care are more likely to be identified as children with educational disabilities, and so those sort of, to make our kids who are already vulnerable even more vulnerable to exclusionary discipline. And we know from studies that exclusionary discipline can disrupt a youth's placement. If you're expelled, you've got to go to an alternative school that might not be in your district or might not be close. So that might the foster parent may not want to transport. They may disrupt. So these things can really mess with the stability of children in foster care. And then we know school instability. The more these kids move around, it increases the risk for exclusionary discipline because, right, if a kid's not feeling connected, they don't have rapport, there's no trusted adult in the building because they've just moved and had to start over. Maybe they are experiencing, academic gaps because they've moved so much. All of these things increase their likelihood to experience exclusionary discipline. And, not that it's on this slide, but we do have direct correlations to, right, the more exclusionary discipline that children experience, the more likely they are to end up in that school to prison pipeline. So manifestation determinations, which I'll talk about next, can be a really important opportunity for us to advocate for school stability and appropriate school services for kids. So if you all, if your clients or your kiddos who you work with end up in a manifestation meeting, highly recommend that you go and advocate to the best of your ability to keep these kids in school, because it's just so important. And it has, it just ripple, the effect of exclusionary discipline really ripple out into these kids' lives. So manifestation determination reviews, you may hear them call it a few different things: manifestation meetings, manifestation determination reviews, MDR. The purpose of these meetings is to ensure that students with disabilities are not unfairly disciplined for behaviors that are a direct result of their disabilities. These meetings are required for students with IEPs or 504 plans when so in three circumstances: when there is an expulsion, meaning, and the law defines expulsion as a removal for more than 10 consecutive days in a school year. The 10-day rule, which is a pattern of removals for similar behavior for more than 10 days in a school year. And then when a juvenile petition is being filed, the school must, before they file that petition, a meeting. And this typically looks like a truancy petition. So if the students missed more than a certain amount of days, the school has a petition. But before they do that, they have to ensure that the absences are not disability related. And in the case of truancy, MDRs, these are only held for students with IEPs, not with 504s. Yeah, and so these are the circumstances where we have those meetings. The meetings, can be contentious. Oftentimes it's, does this child still, is this child going to be able to go to this school anymore? And then obviously the stakes are higher for youth and foster care. They will ask a series of questions in these meetings, but ultimately the decision comes down to two questions. So the first is, was the conduct caused by, or did it have a direct and substantial relationship to the child's disability? Actually, we're looking at, causation. Was this child, say the incident was the child pushed another student in the hallway and the student fell down and hurt themselves, right? This child has ADHD and conduct disorder. We may be looking at, we asked the school psychologist to read off the student's evaluation, maybe read out of the DSM-5 and talk about these disorders, and ask whether the ADHD and the conduct disorder was the cause, or was it had a direct and substantial relationship to the behavior. The second question we ask in these meetings is, was the conduct a direct result of the school's failure to implement the IEP? If the student who pushed this person in the hall was supposed to have a paraprofessional with them during transitions in the hallway, and the para was nowhere to be found and could have prevented this, right? That is the school district's failure to implement the IEP correctly. So if we answer yes to either question, the suspension or expulsion must end. The only caveat to this is unless the parent, educational decision maker, and school agree to a change of placement. We agree that this was disability related. However, we think that this child needs a more restrictive environment, maybe like a special day school. And if the team agrees to that, they can still move the child, but the expulsion or suspension. And then they must conduct or revise a functional behavior assessment and implement a behavior intervention plan to prevent future incidents. If the answer to both of these questions is no, so there was no direct and substantial relationship to the child's disability, and the school was correctly implementing the IEP, then the student may be disciplined consistent with their non-disabled peers. The students still must receive special education services. So if they're told to go to an alternative school, their IEP still needs to be implemented at that alternative school. And then a student may receive a functional behavior assessment or behavior intervention services as appropriate as well. And I'm happy to answer any questions about that. I know it's kind of quick and it's a lot of information. So, great. Yeah, and so just sort of on a positive note, I know there's been a lot of it's sort of discouraging information, right? Like, our kids aren't in the best circumstances and they face a lot of challenges, but there are ways that as adult advocates for our kids can support them in improving their educational outcomes. And Lydia found this really great study that was sort of a composite study of 170 different studies that brought all this data together And these are the top 10 ways we can sort of support kids and improve their educational outcomes. So just engage them, ensure school stability and timely enrollment, promote regular attendance, you know, have good conversations about special education needs, belabor it by reading them all. You all have the PowerPoint, and I highly encourage you to look at the references and take a peek at this study if you have the chance. I think it's pretty hopeful. But yeah, let's see. We really appreciate all you guys do. I was going to make sure I didn't have another slide. This is our contact information, and then our specific emails are in the front of the presentation. And then I think do we have a little bit of time for questions still?
Yeah, we got some time left, and I know there were some questions in the chat. So
yeah,
let's see. I know there was a question just kind of about, I think it was related to the best interest determination, just like somebody said, like, how can you expect a foster parent to drive 100 miles a day for a school? And I've seen that before too, like the burden falls to the foster parent to make those. And I guess the question is maybe like how that decision is made in those situations when kids are moving counties away.
Jordyn, do you want to do it or me? Either one.
I'll let you do. I feel like you're great at talking about the cost burden sharing.
Well, and really so I guess I want to make sure I answer that question correctly. So the foster parent should not be driving. So the school district and the DCS should be like sharing that cost, or the school of origin, really. And so they should be providing the transportation. I do hear the question of like, okay, well, what happens if the child gets sick, or if I need to go to a parent teacher conference or something comes up and I want to go watch my foster child participate in extracurricular things like that, like having to drive. That can definitely be a challenge, and that does put a bit of a burden on the foster parent. But that daily drive to and from the school should be paid for and transported by the school of origin and into collaboration with DCS, not by the foster parent. So that should not be like coming out of the foster parent's money.
Yeah, I haven't had a child counties away, continue to go to their school of origin, but I have had a child with a significant commute, and they were actually it was MMPS would transport to the county line and basically like paid off with the other county. They were, I think, meeting in front of a Tractor Supply and sort of like dropping off the child to ensure she could go to her school of origin. So it is possible they did share the cost. Obviously it gets, not only when we're talking 100 miles, right? The burden of transportation and getting to school may outweigh the benefits of continuing at the school of origin, but I think that's an individualized discussion to have with the BID team.
And I will say there is a random state law that does say that a student can't be transported, like the transportation can't go over an hour and a half each way. So if a bus ride is going to take over an hour and a half, state law doesn't require that. Whether that's special transportation for a student with an IEP or for ESSA for youth and foster care.
There was a question in here about like contacts for help, kind of outside of Davidson County, like specifically in Rutherford and Hendersonville County. And I'm betting more broadly just for people who are in other counties. I know you provided for the Department of Education, the foster care person, like, is that the best person to contact to get information, or like, is there a place to go to find similar contacts?
Yes, and that's what I was looking for. So on the State Department of Education website, they list it and they like update it annually. So I'm trying, but it's it's like hidden in a funky place. And so I meant to actually look it up before I got on this call. So I'm going to find it while we are chatting. And they have a wonderful amount of resources that Jackie Jacobson from the State Department of Education puts up. And she regularly adds new things that when she sends things out to the Department of Education, she puts it in there. So I'm going to find it. I just have to remember exactly where it is. So I will, but it has the point of contact for foster care for every single school district. And so I think they update it annually.
And I don't know if you mentioned it, Lydia, but the DCS educational consultants, is that the correct?
Yes, I feel like it depends on the day if they're education consultants or education specialists. And I think one of them is an old term, but so it depends on who you're talking to, what they use.
They're very helpful though. They're regional, so there should be depending on what county you're in. Sometimes I think those folks are the most up to date on like who to contact quickly for enrollment issues, special education issues, transition issues, and in my experience, they've got like numbers, direct emails, and they're pretty good at getting in contact with people quickly.
Yeah, I think that's
I don't know if, well, you probably all work with, I'm guessing the COE works with those folks. But I know for our region, Jennifer Woods is ours. She's excellent. I don't know them by name, but educational consultants or educational specialists, those are your folks.
No, I think that's a great tip and a great way to get some of that information. Another question that was in the chat too was, are the requirements for the best interest determination and IEP different for students who are in residential treatment? Like, what does that process look like for kids who are being placed in residential care? I don't know if you can speak to that at all.
Like I don't know if the question specifies, but moving from a regular school to residential placement school. I see Chris nodding, I think. Yeah, I mean, so I don't think there's typically a bid conversation for when residential placement is required, just because if that's the level of need for the foster child, then that's the level of need. And typically usually they have schools on campus that children go to. It is sort of a tricky scenario when the kids are coming out of residential facilities. Sometimes they don't really have a school of origin anymore because it's, a lot of my kids, unfortunately, have been in residential for a year or 2 years. And so they're coming out and they're in a different tier. They used to be in middle school when they came in and now they're in high school, or they've just moved around so much. So I don't think that there's a cut and dry answer for if there should be a bid meeting, but typically I don't think there is.
No, I think there's I believe there's state guidance that says there does not have to be one if they're going into a residential.
Okay. I was talking about coming out of a residential.
Oh, I'm sorry. I don't believe there's no.
Yeah, I don't think typically we wouldn't have a bid unless it was a very short stay. And so, but I will say too that if the child has been in a really restrictive setting for a long time, we should probably be looking, and they do have an IEP, I should say. We should be looking at moving from residential to a special day school setting because it's just a smaller setting. Situations where kids move from a residential placement where they've, in the same class all day with the same 10 kids, and then they're put in a high 3,000 people, right? Like we know that's not going to be successful typically. So sort of just that, I think that goes along with like the comparable IEP we talked about. If a kid is receiving special education service all day, when they come out of residential, we want to honor that IEP as closely as possible. So that may look like a more restricted sort of easing them back into a non-residential placement. And feel free to jump in, Lydia, if you have any thoughts on that.
No, I think you're right. And I will say I put in the chat the link of how to get to the foster care point of contact through the State Department of Education website. And so if you go to click on the link and then do non-traditional educational programs, um, oh, you know, I left out a step, but if you click on Title I, Educational Stability of Children in Foster Care, that will also give you a ton of links that this Department of Education through Tennessee uses. And so that can be really, really helpful. And some of those references are also through our presentation. So that might be helpful.
No, that's great. Thank you so much for sharing that in there. There was also a question in the chat about somebody serves on the foster care review board and one of their students was on homebound wait list for Metro Nashville and told there were over 3,000 students on there. So what should education look like for these students while they're on a wait list? Like what to advocate for, I guess, in those situations.
I'll say, I think it probably depends on whether the child has an IEP or not. There are two different like versions of homebound, one for children with IEPs and those who need homebound but don't have an IEP. I imagine the wait list for a kid with an IEP is much shorter because, well, one, there are less children, with IEPs, and two, that there are legal service, special education services have to continue regardless. That child has the right to have this to their special education services. So I don't know if whoever asked the question wants to specify if the kid had an IEP or not, but
I
think yeah, she did. That child has autism. So yeah, I would they should get compensatory services.
Yeah.
But I know we're definitely short staffed homebound teachers, and so that is definitely an issue. Waiting for a spot at special day school. Oh. Yeah, I would advocate for comp ed for sure. And you're welcome to reach out to us afterward if you want to have like a conversation about compensatory services.
Yeah, absolutely. I think that's, I don't know if you've been in contact with the education department specifically, but they may be able to give you additional guidance.
There's another question in there in the chat about how much weight or how much of a say can a youth have in the decision to not leave a school? Like how much of a voice the child is given in that decision-making process, even if there is a long transit.
I mean, it's a whole team decision. And so it's definitely hard. And I think one of the challenges is helping the student advocate for themselves. And if the team disagrees, you can always, try for dispute resolution. But they're only one part of the team. But more deference is given the older they are, but they're not, and they don't get to choose, unfortunately. Yeah. And sometimes fortunately. It depends,
Yeah, that makes sense. And there's another question here about if there was any advice for when a school is answering no to both questions on the manifestation meeting, but clinically they believe the behaviors are directly related to a youth's disability, like what next steps are or what can be done.
You're talking about clinically, like a mental health case worker has a different opinion than the IEP team. Is that, am I understanding that correctly?
I don't know. Yes.
Okay.
I think they responded yes in the chat. Yeah.
Yeah. I mean, not much in that actual meeting. If the parent or educational decision maker signs in disagreement, they say, educational decision maker for this child, the IEP team or the manifestation team got it wrong. This is absolutely related to their disability. They can they can sign in disagreement and file a due process complaint based on disagreeing with the manifestation decision, and then go through that process. So that typically looks like a settlement meeting with the school district, and if we're not able to come to some sort of agreement about what to do, then that can go in front of a judge. But the short answer is at that meeting, it's a team decision. And if the team can't come to a consent, it does default to the administrator about whether the child or whether they believe that the behavior was related to the disability. Meetings a lot of the time, unfortunately.
Yeah, no, yeah. These are tough questions, right?
No, we appreciate them though, because these are, I mean, we disagree with these decisions a lot too. So it just kind of comes down to whether the parent wants to take that further. Yeah.
Yeah. Another question in here was, is the school at the residential facility required to follow the IEP?
Yes. Yes, they are required to follow the IEP. Like they will typically rewrite, and they're not necessarily going to be following the IEP that the child came with. They will rewrite the IEP to make sure that it's consistent with, I guess, like not what they're able to offer, but right. Typically, the child is in like special education all day, residential facility, but they will have to follow any accommodations, goals, and all of that. It is a legally enforceable document. So that doesn't change at residential.
Yeah. Well, thank you all so much for your time today and for taking the time to answer all these questions. This information is so helpful and I think just like so needed to get out there. So we really appreciate you all taking the time to join us and to share your expertise, because this is great. I learned a ton today. So I really appreciate that. I know you all shared your contact information, and the slides are in the chat. So if anybody wants to download that and keep y'all's contact information, I know y'all had mentioned people could reach out with kind of more specific questions later. And I super appreciate that as well. I want to encourage everybody who's joined us today. We have there's a link to the survey in the chat. So please take the time to fill out that survey. Let us know kind of what you thought about today. That's also going to be your access to a certificate for attendance today. If that's important for your records, please save that when you get access to it. And again, just like join us in thanking Jordyn and Lydia for joining us today. Again, super, super helpful. And I hope people will come back and join us next month when Dr. Carissa Smith from the COE at Vanderbilt is going to be joining us to talk about good goodbyes and healthy transitions in placement for foster care. So thank you all so much again.
Thank you. Have a great day.